Let's talk about gift in law. The same way the law recognizes contract of sale, maybe contract of sale of property, either land or house or chattels, anything of some sort, the law also recognizes gift. Gift. You are giving another person something. In this situation, the person is not paying money. The law recognizes it. In case you've ever thought that because it is a gift, as a giver you do anyhow, and if the receiver of the gift does anyhow, you can take it back, please don't think so again. Once you give out a property to someone, and some of the things I'll mention in this video are present in the transaction, you cannot go and ask for that gift again. The law takes it serious. The receiver of that gift can sue you to get that gift that you gifted. Welcome to my channel. This is Law Talks and Gist. If you're seeing my face for the first time, you're welcome. Thank you for stopping by. Please kindly click on the subscribe button, like, share, comment, turn on the notification bell so as to be notified each time there is an upload coming from me. And if you are a returning subscriber, you know I love you always. Now let's dive into the video. First of all, what is a gift? A gift is a voluntary transfer of property without consideration. A is transferring a property, any kind of property, to B without consideration. Let's highlight two words and talk about it. Number one, voluntary. It means you are giving without compulsion. There is no compulsion, there is no threat. It is voluntary. By free will, you just decide to give. And then number two, consideration. We say it is a transfer of property without consideration. Consideration in law means something you're giving for value. Okay, that thing that you are giving in return for services done for you. For instance, I ask someone to clear the grass for me. I am paying you 5,000 naira while you clear the grass. The 5,000 naira that I am giving to you is consideration for the services that you are rendering. So in any kind of transaction, that money that you are paying for something, it is called consideration in law. So now we are saying that a gift is that transaction where there is no consideration. You are just giving, and it must be voluntary. Let's look at parties in a gift transaction. We have two parties, the donor, that is the giver, and the donee, that is the receiver. So now we have a gift in between the donor and the donee. So we have different types of gifts. We have conditional gift, we have unconditional gifts, we have gift intervivors, and then we have gift causa motis. The first one, conditional gift, means gift that comes with a clause, with a condition to be fulfilled before the gift can pass. For instance, if someone says, I give my property at so location to my only daughter, provided she marries at so age, or provided she marries, whichever. So that is a conditional gift. So in that case, if she fails to marry, her failure to marry nullifies that gift. That gift is not valid because she did not fulfill the condition. Number two, unconditional gift, the gift that is given completely without any clause, without any condition to be fulfilled by the donee. Once it is given, it is given. And this one is this is the gift that the law takes seriously. So where it is an unconditional gift, you have to make up your mind. You have to be very intentional, because once you give and all other elements are present, you cannot take back. Nothing nullifies it. Then number three, gift intervivors. That one is a gift that is given during someone's lifetime. You know, maybe for someone who doesn't want to write a will, or you just want to see how your beneficiaries will handle your properties. So during your lifetime, you decide to call everybody and give them gifts. That is a gift given during your lifetime. And then lastly, we have gift causa motis. This is a gift given in anticipation of death. Maybe someone is anticipating his or her death, and you just have to call people and give out properties because you feel you're going to die and all of that. Now, this gift is revocable. It is revocable where the death does not come. Even after giving out the gift, and at the time that you thought that you are going to die, you no longer die. You can now call everybody and say, I'm still alive, please give me my gift. So that gift is revocable. For you to say that there is a valid gift, certain things must exist. Number one, voluntariness. We have already talked about that. It has to be voluntary. It doesn't have to be by force, under duress, under threat. Yes. Number two, intention to give. You need to have the intention, just like the general law of contract where we have intention to create legal relations. There has to be intention on your part to give out. If there is no intention, then there is no gift, there is no valid gift. Number three, authority to give, capacity to give. In law, you cannot give what you don't have. We say, nemo dat quod non habet. The gift that you are giving, do you have the authority, the right to give out? Is it your own? You can't go and carry someone's thing and give to another person. So that is what the law also looks at. That must also exist for a gift to be valid. And then the gift must be given in the presence of people. There has to be witnesses. Remember, a gift can be oral. Okay, it can be oral, you can give without writing, but the statute of fraud provides that when it has to do with property, whether it is a house or a land, it has to be by deed. A deed of gift must be executed. It has to be in writing. So there should be witnesses. If it has to do with land, there must be witnesses to actually see that you gifted this person this land. Without witnesses, I'm sorry, the gift is not valid. Number six, there has to be delivery. The gift that you are giving, you don't just give, you have to deliver it to the person that you are giving. If it is a car, deliver the car key, deliver the car to the person. If it is a land, take the person to the land and show that person, this is the land I'm giving to you, in the presence of witnesses. And then lastly, gift must be accepted by the donee. Without acceptance, everything is nullified. So sometimes one may give another something and the person rejects it. So where the donee rejects the gift is nullified automatically. So there has to be acceptance. So all these things must be present for there to be a valid gift, for the law to recognize a gift as a valid one. But please, I understand that we can give orally, but to be on the safe side, always document your gifts. Let a deed of gift be executed. And don't forget, please, like I mentioned, always be very intentional, because the law takes gifts seriously. We don't want to give, don't give. When it has to do with unconditional gift, once you give, the gift is given. You cannot go and say, the person I gifted insulted me, I am no longer giving him or her, he's not loyal, I want to take my gift back. No. Just like every other contract in law, a gift is also valid. A gift is also recognized. The law takes it seriously. I hope this helps. Thank you so much for watching. See you in our next video.